and there's something going on with you, that's the reason why you're on Ignition-Interlock.
That's right.
So what I'm going to tell you is, if you don't follow these rules, there may not be any more compliance hearings for you. There may. Yes, Miss Abrams.
Sure. So this is a compliance hearing. Do you have a copy of the supplemental report?
Yes.
Okay, so, in the supplemental report, there has been concerns in regards to Mr. Gonzalez's use of alcohol. And,
Energetic, setting the scene. And here we go. Right off the bat, the judge cuts to the chase. This is a compliance hearing, which is basically a probation check-in. But don't let the mundane name fool you. For the person standing before the judge, this is a high-stakes moment where their freedom is literally on the line. Let's see if Mr. Gonzalez is prepared.
some failed to submit into his Ignition-Interlock device. I spoke with Mr. Gonzalez, and he has a couple of reasons that he would like to share with the court. And I do have a couple of recommendations.
All right. So what would you like to share with me?
They were asking, whether there was some periods where I didn't have any tests.
Okay, so whenever you speak to me, you need to look me in the eye so I can read whether or not you're being honest with me, all right?
Okay, yes, ma'am.
So,
Witty, highlighting the drama. Oof! The judge immediately calls him out on his body language. Look me in the eye so I can read whether or not you're being honest with me. That's a classic power move in the courtroom. It instantly puts the pressure on and tells you this judge is not someone you can easily bluff. The vibe just shifted dramatically.
what's going on with you?
So there was an instance where I got into a vehicle collision when I was at work. I deliver mail for the postal service, and those vehicles are.
Okay, I can't hear you. I'm so sorry.
I'm sorry. Do I need to get?
Everyone, please whisper. No, you're sort of mumbling a little bit.
I'm sorry. I don't know if I know.
Speak up.
Yeah. So anyway, there was a medical issue that I had a procedure done, so I wasn't using my vehicle for a while, and then there was an instance there where they had ripped off my catalytic converters to my vehicle, so I had to send the vehicle in. And
So that's the reasons for you not testing to the vehicle.
yeah, because there was a couple windows there that she was asking me about that I didn't have tests for.
Explain the alcohol use though.
I just got careless, I don't know how else to describe it. I've been on the program for a while, and I just.
So here's my question.
Yes, ma'am.
One, did you
Insightful legal breakdown. And here's the critical mistake. The judge asks if he contacted his probation officer about these issues, and the answer is no. This is Legal Probation 101. Communication is everything. The judge lays it out perfectly. Failure to report is what leads to motions to revoke, which lead to jail. This is a masterclass in cause and effect, and a huge warning to anyone watching about what not to do.
call probation and tell them you had a accident and somebody stole your catalytic converter?
No.
Did you call them and say, I'm not going to be testing because here's the reason I'm not testing?
No, yeah. I didn't.
So you're on probation, and when you don't do things, what ends up happening is motions to revoke are filed. Now, some judges, they would have looked at this and they would have just said, file a motion to revoke. And then you would have been taken into custody. Either you would have made bond or you would not have been able to make bond. And then from that, maybe you lose your job, which I don't think you want to lose your job. So the actions that you are taking are not good actions. They're not telling me that you want to successfully complete probation. So far, what you're telling me is you want to be revoked.
I hope I'm not giving you.
No,
that
that's what I'm getting, because you're not staying in contact with probation and you're drinking alcohol. Here's the thing, whether or not you are on probation, it could be for anything. It could have absolutely nothing to do with alcohol, right? Let's say it's a theft case, has absolutely nothing to do with alcohol. You never use drugs, whatever it may be. According to the law in Texas, when you're on probation, you're not allowed to drink alcohol, period. And there's something going on with you. That's the reason why you're on Ignition-Interlock.
That's right.
So what I'm going to tell you is, if you don't follow these rules, there may not be any more compliance hearings for you. There may just be a submission of a motion to revoke. If it's in order, I'm going to sign it and they will pick you up wherever you may be. And then we will hear your case. Do you understand?
Yes, ma'am.
All right, what are you suggesting?
Judge, what I am suggesting is an increase in his test windows for the ignition interlock device. Currently, I believe he's testing 3 times a day.
Mhm.
I would ask that that be increased to 5 times a day.
Mhm.
Weekly drug tests for 30 to 45 days. And an extension of the device for however long the court mandates.
Wait,
I
just
did-
just give me one moment. Let me find this. All right,
And Judge, I just have a couple more things.
let me put this.
Analytical, clarifying the process. This is a really important detail. The probation officer is pointing out that the court-ordered treatment hasn't even started yet. So not only is he not communicating, but he's also behind on his core requirements. The judge is now layering on more intense conditions. More tests, more oversight. This is the last chance package being assembled right before our eyes.
And I'm sorry, you wanted weekly drug testing for how long?
30 to 45 days, Judge.
All right, and then what else are you asking for?
Judge, in reviewing his file, I did notice a TAP was completed and amended conditions were signed for him to go through the intensive outpatient treatment, monthly UAs and sober support meetings. In reviewing the file, I don't see that he's been placed in the treatment or a referral has been sent. So I would also recommend intensive outpatient treatment.
All right, is there anything else? All right, so we're gonna try this and see how it works with you. If there are issues, you need to contact probation because you're looking at potentially just one moment. Yaya, I'm printing something over there. If you could grab it for me, please. You're looking at potentially 2 years in the state jail facility for what you're charged with. And when you go to the state jail facility, that's day for day time. You understand?
Yes, ma'am.
In order to be successful on probation in this court, communication is key. If you do not follow through, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
All right. Is there anything else you need from the court to be successful?
No, ma'am.
All right. Do better. Okay.
Yes, ma'am.
All right. Thank you.
Engaging, posing a question to the audience. Okay, Whiplash. We go from a defendant who's struggling to one who is excelling. Her attorney is moving for early termination, but the state objects. This is a great moment to ask you all, what do you think? Is 10 months on an 18-month sentence enough for early termination, especially if all the conditions are met? Let me know in the comments.
Let me see what I have.
Have this from the shop.
Thank you. Thank you. All right. Who is the person on this?
Ashley Jones for the state, Your Honor.
All right. The court is calling 2024 CR 012991W State versus Kiska Stewart. Could I have parties announced?
Ashley Jones for the state. Lindsay Shopham is Stewart.
And are you Miss Stewart?
I am.
All right, we are here. Defense has filed a motion to terminate community supervision. According to this, the defendant has been placed on community supervision since December 19th, 2024, and it was for a period of 18 months. State, are you in agreement?
We are not, Your Honor, just based on the offense and the amount of time.
All right.
Yes, Judge. So this was a case, it's out of your court, but it was reduced to a misdemeanor. She was placed on deferred adjudication for 18 months. So as of today, she's been on nearly 10 months. Even since the supplemental report that you're looking at was completed, she has completed her community service hours. I provided the state a copy of her donation that she made to the Texas Advocacy Project for $309. She's completed her BIP. She has now completed her community service. As you can see, there's been no concerns of her violating any no contact or no harmful or injurious contact orders. She's up to date on her fees. We're asking the court, she has a young child and she's trying to go to school, cosmetology school. And since she has been on more than half of the term, we're asking the court to consider our request for early termination.
All right, this is what I can tell you. I will strongly consider terminating you on December, because December, that will put you at a year. And what I would like is I would like the complainant to be contacted, to be notified. If you have no violations and everything is fine, December, I will terminate her.
Could I?
Sure.
So if this, not only the BIP, I've also completed VENT program through the Peace Initiative, as well as the fatherhood campaign. Being able to get off early would give me the opportunity to renew my Texas insurance license, my health and life insurance. With Medicare coming up, that is a huge opportunity, not only for me, but for my son to be able to provide for him. Open enrollment ends December. So if I could get that license.
When you say it ends December, what date does it end in December?
So it starts October 15th and I believe it ends December 1st. So there's that 2-month period, or and maybe the 31st. But there's a
All right, if somebody bring me proof that it ends at the beginning of December, because I'm not sure if it ends at the beginning of December. If y'all bring me proof of that, then I will consider early termination in November. But what I need is this is what I want you to take away from today. If there are no violations, state, you're going to have to reach out to the complainant and let them know that in November, if there are no violations, and if there's proof that early.
Summarizing, highlighting the contrast. And that's the perfect note to end on. Two defendants, two completely different paths. One is getting a stern final warning. The other is getting a clear path to freedom. The key difference? Communication and compliance. The judge's final line, whether it's signed or not is 100% dependent upon you, is the ultimate takeaway. Your actions in the justice system have direct consequences. It's a powerful lesson wrapped in two very different stories. 6.